I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am if you're going to turn around and start smiling and doing all that. This is not a
I was just
bond denied.
They arrested me there.
Yeah, I know. Why? Because we had
Said you
warrant.
Warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was
Oh my!
You recall?
Not what she said. Told me.
Your Honor,
Waiver or no? What are we?
Yes, Judge.
Well, that's okay. The boxes are checked, but it's not my case. All right.
And this should be a no contest plea. Is that right, Judge? Do you have
Contest. All right. Mr. Holston, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the hope you got?
yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is, sir?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that, sir?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
You understand that?
Yes.
Right. Basis for the no contest plea?
lack of recollection, Your Honor?
All right. To that charge, sir, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
All right. You had signed on your behalf an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including the rights contained under paragraph 5?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided Ann Arbor Police Department report for their case number 24-61658. Any objection to the court having reviewed that report?
From defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 17th at 8:30.
July 17th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Olson. Oh, good morning.
This morning.
Court calls case people versus Stephen Huska. I heard what Ann was saying.
Jessica McFarland requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Michael Gaddy.
Really? How is he as a supervisor? Okay. Permission to practice is granted. Wow.
Brother, friend, I get that same review.
Yeah.
We have the defendant state their name.
Rahaska? Oh, they're in there doing it now. Thank you, officer. Mr. Oscar, state your name, please.
Steve Haska.
All right. And what are we doing?
We are requesting to adjourn for further negotiations with the people.
Do we have a green sheet?
Yes,
It's gonna hold it.
sorry.
Eddie tape.
No,
Let's see. July 9th work.
yes, Your Honor.
Matter will be adjourned without objection to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case of the people versus Sarah McCormick.
Good morning, Your Honor. Andrew Cito, PH 74447 on behalf of Defendant Sarah McCormick.
Mr. McCormick, can you unmute? State your name.
Hi there. I'm Sarah McCormick.
Thank you. All right, what are we doing?
Good morning, Judge. I spoke with the prosecutor, and me and the prosecutor have been working together, and she offered me a deal to reduce this down to a misdemeanor for a controlled substance use. I haven't had the chance because we just spoke with the prosecutor yesterday. It was pretty late, and so I just need
So
to.
you did an adjournment?
Yeah, just an adjournment so I can just go over this with my client and then come back here for the conviction.
Will July 2nd work?
Yes, Your Honor.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued. Thank you, Ms. McCormick.
Thank you.
Court calls the case, people versus Matthew Kennedy.
Good morning, Your Honor. May it please the Son of Court, David Burgess, on behalf of men.
Her name, sir?
Matthew Kennedy. Your Honor, we are asking for an adjournment of the probable cause conference. My client did complete Bear River and it might work into the plea, but the prosecutor needs the proof of that, so I need to get it from my client.
All right. Couple of work.
Yeah, I did want to address bond if we could just briefly.
I'll adjourn these matters to July 2nd, 2026, 9 a.m. As the bond.
Thank you, Your Honor. Judge, my client failed to appear on a date. He had called me later that day, got his dates mixed up. Tried to walk him in on a Wednesday, but he was not able to meet me at the one Wednesday. I was able to do it that day, but did complete Bear River, Judge, and he did contact me. These aren't assaultive cases. I understand the concern the court might have, but does have stable residence area, and I think he will return, Judge, based on.
So how do you come into custody?
I don't. How'd you get?
I was at work. Picked up at work.
Yeah, picked up at work.
They just came and got you?
Yeah, I didn't cut my tether off or nothing. I didn't like abscond. I didn't.
He had a tether on, Judge. I mean, yeah, it was pretty easy to find, I guess. So.
Yeah, didn't die or nothing. I kept it charged. I kept doing my weekly check-ins. I kept going.
Why was the first thing that came to your mind cutting off your tether?
No, he said he didn't
I
cut
thought
off.
No, I know he didn't say it. Well, why did that come to mind? Never mind.
Because I didn't.
It's context, Judge. That's all it is. Context.
Yeah, like I wasn't trying to go on a run. Oh, sorry.
You're good.
Anything from the people on the,
Thank
all
you.
right. What I will do is I will reinstate the defendant's previous bond in this matter.
Thank you, Your Honor.
All right, thank you.
Thank you. Hey, you know,
Let yourself, you want me to change my mind or?
no, he said thank you, Your Honor.
Oh, I know what he said. If it doesn't go, I'm gonna change my mind.
Leaving quickly.
Yes. Court does call the case, people versus Robert Anderson.
Your Honor.
Good morning again, Your Honor. May it please the Son of Court, David Burgess, on behalf of Robert Anderson, who's appearing via Zoom, Your Honor.
Hello, Robert Anderson.
Okay, thank you. All right, what do we do?
Your Honor, the people have indicated to me that there's some additional discovery we're going to have to review and obtain prior to the exam, so we're requesting another adjournment of the probable cause conference.
How much time are you gonna tell?
Should be not this, a couple reports from YPD.
All right.
Which is fine, Your Honor.
Probable cause conference, July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the people versus Charles Johnson.
Your Honor, as about the people.
Oh, on behalf of Mr. Johnson, who'll be approaching the podium and standing to my right. Mr. Johnson, once you get up here, please state your name for the record.
Was that supposed to be her case and you took it, Feltes?
Yes, Your Honor.
Lady, where are you from? Okay, don't let her do that to you. All right, go ahead. I'm sorry. Your name, sir?
Charles Bernard Johnson II.
And Your Honor, at this time, we are asking that the matter be set for exam.
Discovery is complete.
To my knowledge.
What would
We are on June 30th.
people have their witnesses available June 30th? All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Thank you.
Bond will continue. Thank you. Court calls the case of the people versus Amanda Brown.
Your Honor.
Morning again, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Amanda Brown, who's approaching.
Your name?
Amanda Brown.
All right, this is a waiver.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing, you'll proceed to circuit court for further proceedings.
Yes, sir.
People also waive their right? Yes.
Not that official offender notice as well as an agreement. My understanding is that it's currently on probation at circuit court. There would be an agreement to have her have concurrent probation, no upfront jail with her parents.
That's our understanding as well, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count. Mr. Burgess.
Waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 11th at 1:30 with Judge Cuffey.
August 11, 2026, 1:30.
Okay.
Bond continued.
I'll call you.
All right, I'm done.
Court calls case of people versus Douglas Hill.
Over for the people, Your Honor.
And Assistant Public Defender Zach Venue with on behalf of Mr. Hill, who approaches on the case ending in 163.
Morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Hill on 2111.
Douglas Hill. Thank you. Both of you are requesting an adjournment.
Your Honor, yes, we're trying to keep the cases together, and I believe I spoke with the prosecutor this morning, and she's still waiting on a CCTV video. And as soon as that happens, we'll set for exam.
How much time are we going to need to get that?
Spoke with the agency yesterday. They indicated that it was just processing.
It was on,
The request, they had uploaded it, but it's processing.
got it. So a couple weeks, you think, gentlemen?
I would defer to the prosecutor, Your Honor.
Pardon?
Good, Your Honor.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Morgan. Is it G-Lander?
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Morgan Jalander.
Your name?
Morgan Jalander.
You're requesting an adjournment?
Yes, Your Honor. 2 weeks is okay, Judge.
It'll work.
I think I'm.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case people versus Safara Kent.
Jacob Kennedy for the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kent, who's approaching, Your Honor. State your name for the record.
Chief for Kent.
You're requesting an adjournment. Will 2 weeks be enough?
That be enough to get them?
Oh, you need,
Your Honor, I believe there's some additional charges coming.
That is correct.
So I don't know if they'll be able to get them arraigned on those, but I would think 2 weeks, depending where they are in the swear to process.
My understanding that swear to is going to take place this interim. So
okay, is he then set to be, the swear to will happen, is he set to be arraigned this afternoon?
that, no, Your Honor, just swear to.
Purchase of offense is complete. Right.
That's correct. There are 3 additional.
Gotcha, okay. And so that this wasn't on where the officer was on call.
No, but for this.
Got it. Okay, so that's where two is gonna take place. He would then have on those charges. I don't. You want me to put it out 2 weeks or 3? Because here's the reason I'm asking. I don't understand if the swear to is gonna happen. He's in custody. I don't know why we couldn't add him to the list to have him arraigned on those 3 charges this afternoon and then set it 2 weeks out. But if you don't want me to do that,
That's fine with us, Your Honor.
all right.
I agree. Or 2 about what exactly is going to happen this afternoon. That maybe they can get him on the list to be arraigned as well. Certainly.
Zach Ward's involved.
Yeah.
If he's involved, this isn't gonna happen.
I'll make sure he knows that.
All right, so if the officer's gonna swear it out today, we communicate with the magistrate to see if they can get him arraigned and then set it for the 2nd? So I'll adjourn this out, probable cause July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Dominic Brewer.
Morning, Your Honor. Name is Cook for the people.
Good morning, Your Honor. Kyle Riddle on behalf of, but not with Mr. Brewer. Your Honor, it's my understanding that Mr. Brewer was picked up in Canton yesterday. Because of a hold that he had already. So I think it's my understanding, I believe he's in the Wayne County Jail or in the Canton lockup. I spoke to a family member yesterday late.
Well, we have. Yeah. We have it. That yes, he was picked up. And they filed. A conditional bond violation.
Okay.
All right.
Okay. Thank you. I wasn't aware of that bond violation, so thank you for that, Your Honor.
Yeah, this is the report. I think this is the Canton report that they then filed with this court, took him into custody down there.
Understood.
So at this point, what I will do though is I'll issue a bench warrant for his failure to appear. That way we can go get him. Bond will be setting him out of 10,000 cash surety.
Thank you, Judge.
You. Court does call the case of the People versus Lorenzo Murphy.
Right, Your Honor.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Lorenzo Murphy. Your Honor, we're asking for an adjournment of this matter. I just got this case. I was just appointed on it.
Are you on both cases?
Yes, Your Honor.
Need 2 weeks.
Yes, Your Honor.
July 2nd, 2026. Any bond continue. Thank you, sir. Court calls the case of the People versus Daryl Howell.
People. Good morning, Your Honor. Nathan Coulter requesting to
Michigan. Okay, permission to practice is granted.
Ed Rodriguez on behalf of Darrell Howell. Your Honor, I just was appointed. The contact information is not good. I don't have an email. I'd asked for an adjournment just for purposes of contact with him. I do have an address. I did mail him a letter yesterday, but I haven't got any confirmation back. I know he's on probation, Wayne County.
He's on probation in Wayne County?
On probation in Wayne County. So in the event that I reach him, if the court were to adjourn it, this is the first PC.
I understand that, but I think, given the nature of the charges, I'm gonna issue a bench warrant for surety to appear.
Okay.
Bond will be set at a 10,000 cash surety.
Thank you.
We'll issue immediately. Thank you. Court does call the case, People versus Christopher Madison.
Bring it over to the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Madison.
In both matters.
In both matters, Your Honor.
Your name, sir?
Christopher Madison.
Thank you. You're requesting an adjournment?
Well, Your Honor, I did attempt to go speak to Mr. Madison yesterday. He indicated he may not want the services of the public defender anymore. So
what? He doesn't want the services of the public defender? I'm gonna hire his own?
No, I
Go ahead.
do a letter and I plead guilty on all charges, sir. So I figured I didn't need a public defender to plead guilty.
Okay, Mr. Madison? Did I receive this letter? I don't think so.
Top of my head, it did not sound.
Yeah, I don't know that I've received a letter from you.
Oh.
Yeah, and why do you want to plead to 2 felonies?
Because I'm
5 years.
sir, I was under the influence of drugs.
Okay, hold on. I don't want you to, well, just listen to this, Mr. Madison. I don't want you to say anything about the charges.
Okay.
Okay? I'm just trying to figure out why you want to proceed in that fashion, but hold on a second, Mr. Bukovich.
Your Honor, as I said, I don't want my client putting anything on the record that could incriminate himself. Obviously, he cannot plead at this stage. We're at the PC stage, which you cannot plead to a felony at the PC stage because this is a.
Oh, you can. Yeah, I don't take the plea.
You're not going to take the plea. So ultimately, I believe at this stage, our best option would be an adjournment for us to have time to consult with our client about the implications of a plea.
Let me ask you this, sir. If you're trying to get this done with.
Yes, sir. I'm trying.
Okay, hold on. It's not gonna happen however it resolves itself. It's not gonna happen less quickly or more quickly if you have an attorney, right?
Okay.
So I don't know, I think having the public defender is in your interest. The important thing, more so than it being quickly, is that all of your rights as you go through it and you go, whatever your decision is, your decision. But that to make sure that all your rights are protected. That's part of the reason that they're there and that your interest is protected. Okay. So I think what you should do, I'm going to adjourn these out a couple weeks. Okay. And then let you talk to the public defender, tell them what you want to do and talk it through with them. Okay. Fair enough. Okay. All right. I'll adjourn these to July 2nd, 2026, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court calls case, People versus Deontay Jordan.
Morning, Your Honor. Bring code to the people.
Good morning, Your Honor. J. Grant Miller, 58658 on behalf of Ms. Jordan. Your Honor, I was communicating with my client last night. He indicated having some transportation problems. He lives in Lansing. I encouraged him to get the bus down here. I would request
the whole bus thing, but go ahead.
Well, I did suggest the flyer does travel from Lansing to Ann Arbor, and then he can get the number 4 down here. Literally, I texted that to him, Your Honor. Not here. I understand that people are probably going to request something.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000 cash or surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus Jason Smith.
Ready, Your Honor.
Morning, Your Honor. Great. Look for the people.
Good morning, Your Honor. James Spifelsky appearing on behalf of Jason Smith, who is approaching. Can you please state your name?
Jason Smith.
Thank you. Your Honor, this is our first PCC. I'm asking for an adjournment for discovery and investigation on this, please.
July 2nd, 2026, 9 a.m. without objection.
Thank you, Your Honor.
Bond continues.
Thank you, Judge.
Court calls the case People versus Janine Lebrel.
Morning, Your Honor. Raymond Cook for the people.
Praise.
For the record, Your Honor, Stuart Collis on behalf of Ms. Lebrel, who is approaching and coming to my right.
Hello, your name?
Janine Lebrel.
Thank you.
Your Honor, today for PCC, we are asking for an adjournment of this matter to do some further discovery. There's some videos that we need as well as some negotiation in this matter.
Probable cause conference will be set July 9th.
Very well. Your Honor,
26,
I have a brief request on the bond. My client has to go out of state for her nephew's birthday in Columbus, Ohio. And while I am sad that
to Ohio,
I know, right?
No, go ahead.
It's late June, and she obviously will be returning back where her partner home is. But
do we have travel dates?
Yes.
Yeah, it's the last Sunday in June for my nephew's first birthday. And I'll be staying with my parents.
So the 28th.
The intention is to drive down on the Saturday and then come back the Monday.
Saturday, 27th.
So 27th to the 29th. Any objection from the people?
No, Your Honor.
All right. Her bond will continue. You get me, you're doing it. And then I will allow her to travel to Ohio for those 3 days. Enjoy.
Thank you very much, Your Honor. See you on the 9th. Thank you.
I'm sorry, Miss Zenda. I'm really sorry that you're from Ohio. Court calls the case. People versus Wardell Smith.
That is on behalf of the people, Your Honor.
Morning, Your Honor. Robert G. Kill on behalf of Wardell Smith.
Much better person having been in Michigan, but
Today's time for a PCC.
Your name, sir?
I'm sorry. We set this for exam.
Discovery is complete.
Yeah, it's a reauthorization. Everything's the same. Yes.
All right. People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. before Judge Barr.
Judge, may I make a bond argument?
May.
Judge, because this is reauthorization, the victim, who is the mother of his children, never showed the first time. That being, pardon me? His wife, I'm sorry, his wife. Since he's been in jail, since April 21st, he's done 3 weeks of Dawn Farm program. He could do that outpatient. He's also continuing with CMH. He could do that outpatient. Done a lot of really good programs in the jail, 12-step, the DV1, DV2. I know what the prosecutor is going to say, that he called the FBI. He admits he called the FBI. He was worried about his children. After he called the FBI, his son then called him, say, Dad, everything's okay. He tried to cancel the FBI appointment. So again, it wasn't.
But that, I've heard this before. It wasn't just the call to the FBI. There were other calls that were also initiated by this defendant regarding police involvement.
Careful, what do you want to say? It was for the benefit of your children? Yeah, Judge, he did call, what, Pittsfield?
Yeah.
He did call Pittsfield. Again, it was concerned about his children, Judge. Again, there's a serious charge. We understand that, but my client could live with his mother in Ypsilanti. She's already said it's okay for him to live there. even if it were untethered, the other issue is, Judge, and I know this really doesn't go to the case. He has a lawn business that all his equipment is just in a storage area that's about to be repossessed and sold out. And we're asking the court to please consider just a reasonable bond for this man. He will stay away from the victim. And the calls he made were for the benefit of his children, who then called dad and said everything's fine so far.
Once again.
I'm gonna object. While the defendant may say those were for the benefit of those children, some of those calls that involved him reporting a shooting, having law enforcement respond to that house for those children, or basically, in a sense, swatting that residence for a shooting that did not occur. Beyond that, he did call the FBI, and there were also allegations of drug use while he was out on bond. I also have concerns given in one of his calls on the 15th, he mentions, I want to know if you can help me get back in good graces with my family, that I have a child with my wife. Tell her not to cut me out of the picture. Tell her that I still love her and I need her back now. I need some support. So I have concerns that he has shown this court time and time again that he cannot follow bond and is a danger to not only the victim, but the community and law enforcement by using their resources and having them to respond to things that are not happening. And also harassing this victim. And I mean, at this point, it was reauthorized because she came back around and was on board, because she was in fear for her life because of this defendant. So I think at this point, bond is appropriate, given that he has shown this court he cannot follow the orders of the court. And is still even now attempting to try and get a hold of this victim, wanting to call her directly, having other people in his family reach out to her.
That's well,
Judge, he said he was never trying to get a hold of the the victim. It was regarding his children. But this is the case. She never showed the first time. And again, I don't know if she's going to show the second time, but the court should.
But I've heard this bond argument before. I mean, I don't know of any circumstances that have changed from the court's perspective. It's actually gotten worse, quite frankly.
A reasonable bond to protect society.
I think the bond is reasonable. Motion denied. Court calls the case of People versus Tariq Wilson.
Assistant Public Defendant Nick Bukovich on behalf of Mr. Wilson.
Mr. Wilson, is there somebody you can ask to help unmute? Good morning.
All right.
Okay.
Okay.
Thank you.
Welcome.
Thank. Mr. Wilson, can you state your name, please, sir?
Derek Wilson.
Thank you. You're asking for an adjournment.
Yes, Your Honor, I filled out the visit application. I'm just waiting for a response. So
How fast do you typically respond? Do you know?
well, they told me it would take 2 days to process that, but apparently that may not have been true because I sent it more than 2 days ago.
All right, he's in MDOC.
Yes, he is.
I think the court's familiar with those. Mine, it could take weeks.
Yeah. All right, let me adjourn this out to July 16. Won't affect defendant's custody status. July 16, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Natasha Brazelton.
Morning, Your Honor. Raymond Cook for the People.
And Assistant Public Defendant Nick Bukovich on behalf of Ms. Brazelton. Should be appearing via Zoom.
Not checked in.
Yeah, I did speak to Ms. Brazelton this week. We were playing a little bit of phone tag. We do have a finalized offer, so I cannot explain her lack of appearance here today. However, I did speak to her this week, so I would be requesting an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount $10,000 cash surety. Court calls the case People versus Lowry Shinabar.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Shinovar Lowry.
Yes, it is. I'm sorry.
Kevin Williams, Shinovar Lowry Jr.
Your Honor, we're hoping for an adjournment to review discovery.
All right. How much time? 2 weeks would be enough for it?
I think so, Your Honor. Yes.
Will be adjourned to July 2nd. Bond continue.
Thank you, Your Honor.
Court calls the case People versus Austin Bird.
Hello.
Morning, Your Honor.
Oh, here we go.
Wagaga requesting permission to practice pursuant to Michigan Court Rule .120 under the supervision of Assistant Public Defender Nick Bukovich on behalf of Mr. Bird.
Permission to practice is granted. Sir, state your name. Mr. Bird?
Yes, Your
Can
Honor.
you state your,
Austin Bird.
thank you. All right, what are we doing?
We're just requesting an adjournment for ongoing plea negotiations, Your Honor.
Adjourn this matter to July 16, 2026, 9 a.m.
Your Honor.
Bond continue.
Your Honor.
Thank you.
Court calls the case People versus Ayad Abulez.
No one for the people, Your Honor.
Morning, Your Honor. Assistant Public Defender Davi Lebo on behalf of Mr. Abuelas. Mr. Abuelas, can you tell the court your name, sir?
Iyad Abuelas. Good morning, Your Honor.
All right, what are we doing?
Andrew, I'm going to request you to adjourn both matters for discovery, and I would like to address bond as well.
Probable cause conference, 2 weeks or you want 3?
I would ask for 2 weeks, Your Honor.
July 2nd, 2026, 9 a.m. Go ahead, Esteban.
Thank you. With regard to bond, Mr. Abuelas has told me that he has stable housing located in Ypsilanti. He does indicate to me that he has some health issues, needs a medical appointment with regard to that next week, as well as an appointment with a psychiatrist he's going to be needing to reschedule as a result of his custody today. He also indicates to me that he has 2 children, a 1-year-old and a 3-year-old, and he's quite anxious of being separated from them, and he anticipates they feel the same way. They're currently staying at home with his wife. But if we'd have no objection to home confinement tether, and Mr. Boyles indicates to me that he could post up to $1,000 in bonds. So we'd ask
how much?
Up to $1,000, Your Honor. And so we'd ask the court to consider a personal bond or in the alternative, a 10% bond that Mr. Boyles will be able to post.
Response.
My understanding that the defendant's like just remained on new charges yesterday. And
yes,
criminal history. If the court was inclined to release him, we would also be asking for it. Okay.
Well, he lives in Ipsy.
Does, Your Honor. And he has provided me with an address that I can provide to the court.
Given that argument, the court will modify the defendant's bond to a $10,000 10% bond. Defendant must be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
Yeah. Thank you.
$1,000.
Court calls case, People versus LaShawn Charles.
Your Honor, bring me to it.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Charles, Your Honor. She is
Good
on Zoom.
morning.
Judge.
Good morning. Your name?
LaShawn Charles.
All right, what are we doing?
Your Honor, I'm asking for a brief adjournment. There is an ancillary issue that I really want to clear up. The people have made an offer. I just want to confirm that everything is good in that way. I'm going to have Ms. Charles speak with someone in my office with expertise on this issue.
During it July 9th, 2026, 9 a.m. bond continue.
Thank you, Your
Thank
Honor.
you.
You need a green sheet.
Oh, I'm sorry, Judge. I have it. I may approach.
Court does call the case of the People versus Wesley Brand.
This is pursuant to Michigan Court Rule 8.101. For prosecuting attorney action.
Permission to practice is granted.
Your Honor.
This is Public Defender Davy Lebo for Mr. Brand. Mr. Brand, if you state your name.
Wesley Brand.
And Your Honor, Mr. Brand will be waiving. I reviewed the waiver form that he has just executed at your podium.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged or the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
We'll also waive the right. Preliminary examination having been waived, defendant's bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We waive formal readings and stand mute at this time.
Defendant every way formal reading standing mute. Court will enter not guilty plea. Pretrial will be set for
22nd at 1:30 for Judge Slay.
July 2nd, 2026, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, bond continue. Court calls case of the People versus Aaron Davis.
Haley Zinn on behalf of the people.
Oh, is it? No.
Yeah.
Assistant Public Defender Zach Vinny on behalf of Mr. Davis, present via Zoom. Sir, can you please state your name for the record?
Wow. Okay. That's it.
Aaron Michael Davis.
Oh, there we go. Okay, thank you, sir.
Your Honor, we would set exam on this matter.
You need an exam.
Yes.
And he is located where?
It's the new path in Flint, I believe, Your Honor.
Retreat.
Yes, Your Honor.
Okay. I'll set it for exam. Is he going to be permitted to leave treatment?
Oh, well, I had a discussion with him yesterday or yesterday, the day before, and I believe he stated that he would be able to be transported here for the exam.
Okay. Is that correct, sir?
Yes, Your Honor.
Okay. Do you know about how much time they might need to try to make that happen?
2 weeks, Your Honor.
So they can't do it in 12 days. I can
12
either
days.
do it in 12 days or 19 days.
12 days. The guy's with me. My care coordinator is with me right now as we speak. He said 12 days is fine, Your Honor.
Okay, so we can do the 30th?
Yes, sir.
All right. Then, and discovery is complete?
To our knowledge.
People have their witnesses available the 30th? All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. That's before Judge Washington.
Thank you. God bless him.
Take care.
Yeah,
Thank you, Your Honor.
Court does call the case of the People versus Maurice Robinson.
No, for the people, Your Honor.
Studies in.
Julie Gaines, Senior Assistant Public Defender representing Mr. Robinson. Yeah.
Okay. Sir, can you state your name, please?
Please, Robinson.
All right.
Yeah, Mr. Robinson is in custody in Illinois, I believe.
Sebago County. Yep.
I was able to schedule an appointment to meet with him on June 23rd. I'd asked for a PCC date after that day.
Okay. But we're gonna need at least 2 weeks. How? All right. You've got an appointment with him on the 23rd.
That's correct, sir.
All right, so what I'll do so that we can have enough time for a writ, if they'll honor it, is probable cause conference will be adjourned then to July 9th, 2026, 9 a.m.
Yes.
Bond, thank you.
Thank you, Your Honor.
Thank you, sir.
I'll see you by Zoom on 23rd, sir.
Court calls case People versus Grant. Jay.
Morning, Your Honor, people. Morning, Your Honor, Michael Gaddy, Assistant Public Defender on behalf of the.
Your name?
Grant Matthew Duche.
What are we doing?
Grant, we'd like to set this matter for.
Like to do what?
Set this matter for exam, Judge.
Discovery is complete?
Yes, Judge.
Would people have their witnesses available the 30th?
Yes, Your Honor.
All right, preliminary examination, June 30th, 2026, 9 a.m. before Judge Barr.
Thank you, Judge.
Thank you. Court calls case People versus Xavier Bonner.
Your Honor, Peter Winter on behalf of, I'm standing in for Mr. Amadeo, Your Honor.
All right.
State your name for the record, please.
Xavier Bonner. What are we doing?
Your Honor, I'd like to ask that the PCC be set over to the 9th. I also understand there's a probation violation because he didn't get tested. I've talked to him.
It's not only that he didn't get tested, he didn't even report. I wasn't aware.
I don't know that Mr. Amadeo was his attorney at that time, Your Honor. I have made sure that he's going to, his mother is here with him today, and I'd like to adjourn the violation over to the 9th. I've made very clear to him that he's got to report this morning.
When he was arraigned, he was told to go over.
Well, I was not present. I'm just indicating to the court that I've told him very emphatically his mother is here. He's going this morning.
Okay, is he saying he didn't know? Is that what he's representing to the court? Because he needs to be careful if that's what he's representing.
I don't understand.
No, I didn't.
Tell the judge.
I didn't understand. Prepare new orders. Is he working? What are you doing when you're out? I work at McDonald's.
Well,
Who else? How long have you worked there?
for like 5 months.
He lives with his mother and I believe his sister, Your Honor, and they're both here in the courtroom. His mother's here in the courtroom with him.
We'll prepare a new order for community corrections. You need to go over there before you leave this complex. You understand that?
Understand.
And so I want that order and an order for a GPS tracking location tether. And then I will adjourn this to July 9th, 2026, 9 a.m.
I'm sorry, I didn't hear when, Your Honor.
The 9th,
Thank you, Your Honor.
10 a.m. Bond continued with those added conditions.
Thank you, Your Honor.
Court calls the case, People versus Maisha Gaines.
Read the notes for the gateway, Your Honor.
Good morning, Your Honor. Joy Gaines, Senior Public Defender representing Maisha Gaines, who's approaching. Would you please state your name?
Maisha Gaines.
I'm presuming no relation.
No, you're not.
Okay, all right, go ahead.
Your Honor, we have come to,
This work, it's amazing. Go ahead.
Your Honor, we have come to a resolution in this matter, but need some additional time to effectuate it. It's a global resolution with a case in the 14B District Court.
All right. So does she need to get there first or?
Yes, Your Honor. She's currently scheduled, I wanted to say, for June 30th for a pretrial there, but we are trying to get an earlier date for her there. The attorneys and paralegal over there working there.
All right, but you might get the 23rd if it's an early. Why don't I just do this? July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Terrence Hall.
Alexander, on behalf of the people, Your Honor.
What is Bellinger doing? Who? Where is?
I think we withdrew from this. Good morning, Mr.
Hey, how you doing?
Yeah.
Mr. Winters, is this your case? Are you're here for Mr. Amadeo?
I am, Your Honor.
All right, this is another one of his.
State your name for the record, please.
Terrence Hall. All right.
Mr. Amadeo was appointed on this case about 5 days ago. He hasn't had a chance to speak to Mr. Hall because he was bonded out. He's tried to visit him in jail and he bonded out. So we would request this be put over to the 9th.
Any objection from the people? Probable cause conference adjourned July 9th, 2026. 9 a.m. bond continued.
Thank you, Your Honor.
Here. Court calls the cases of the People versus Taiwan Grigg.
As follows for people.
Who's this?
I still correct on 2024 case.
Corrected.
Joy Gaines, Assistant Public Defender representing Mr. Griggs. She got going.
I got.
Okay.
Wayne.
Stephanie Cannon on behalf of Mr. Griggs, Your Honor. Thank you, Joy. Your Honor, we are asking for an. Did Mr. Griggs already say his name?
Mr. Griggs, apologize.
Thank you. We are asking that the 2025 case be adjourned because additional discovery has been requested. We're asking that the 2024 matter be set for preliminary exam.
I, however, don't have a problem doing that. However, I don't have questioned, I believe, twice, not 3 times, the corrected order on the 24 case.
And my apologies, Your Honor, because I thought I had given that to the court. If I have not, I will resend it.
I don't know if
You correct what I received. It's one that was incorrect twice, and then I received one for the wrong case. Your Honor, I will revise them and resend them again. I thought Ann and I thought I had fixed them, so it
that didn't
addressed.
well, did
Not work out well, but I will try again.
I'm not going to keep waiting on this order. I'm going to ask the jail if we can take him back.
And we'll do it.
In order, then I'll bring it out. I'll be able to sign the order. Then everything will be in place since we've asked for it numerous times.
No. Fix back, we'll ask them.
Thank you.
We're coming right back. We're coming right back.
Yeah. Court calls the case, People versus Hetty Dick Diaz.
Assistant Public Defender Davi Liba for Ms. Diaz, who I am hoping is appearing on Zoom. Your Honor, I have been attempting to.
Rings eternal, but go ahead.
It does, Your Honor. Brett's not here. I've been trying to reach her for the past few days and I have not been successful in doing that. I have generally been able to in the past, so I am surprised and would ask for an adjournment.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash share.
Thank you, Your Honor.
Court calls case versus Amanda James.
And the bill for the people, Your Honor.
This is Public Defender's Act, committee with on behalf of Mr. James will approaches.
You guys got to make sure to clear that way when transport's coming through, Mr. Lebo.
Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the time set for a bond hearing. Ms. James, as you remember, as you recall last week, Ms. James was ordered to go to community corrections to test. She did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh, yeah, I remember. We didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections.
And did.
She's here on campus. She left the building and I remember her walking out. She said, I'm going over. We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh, yeah, I know, but it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money, and then had to go to Burger King.
Where does she live?
1282 Medford Drive, Huron Heights.
So in this county?
Yes,
So when does it, 4 hours or
Your Honor,
2 hours to go home, come back,
3 hours.
and then do that? And I don't know where the Burger King comes in.
It was not 3 hours, Your Honor. I was going 45 minutes. I
Yeah,
have my test.
tell me that.
Please, Your Honor.
Because we called over.
She said she called you when I got there and I sat for like,
I know. She did.
oh.
But she did get over and test.
She did come. Yeah.
Yeah. Then she left.
I did.
Then she, what, Your Honor, I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had
Said
issued
you put a
warrant.
warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was,
Oh my,
you recall.
not what she said. Told me.
Your
Your Honor, I
Not talk, turn around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am. If you're gonna turn around and start smiling and doing all that, this is not a
I was just.
bond denied. I'll set it over to July 2nd.
You're not even giving my information.
Keep talking. You want your case now, Ballinger? Court case, People versus Nicholas Dragos.
People.
We're gonna go on behalf of Mr. Draco.
Not check. What's that for?
Did you want to say anything or no? What were you gonna do?
I was waiting for
You can stare at that screen all day. That's not gonna happen.
I was waiting on your cue, Your Honor.
You were waiting on my cue?
Yeah, I thought,
What?
usually you say, what are we doing? But I didn't know if that was.
Oh, okay. All right. Okay, so you need a cue.
Well,
All right. We can.
I didn't want to interrupt you.
What are we doing?
We were going to request an
So
adjournment.
we're gonna be the same thing because your client's not here.
Right.
Yeah.
We were just going to mention there's an intensive amount of discovery, but he's not here. So I guess my request for an adjournment might be irrelevant.
I will say,
You can make the request.
I will say,
Nick, why are you trying to save him?
because he will save me in the past, Your Honor. Public Defendant Nick Bukovich on behalf of Mr. Dracos. I will say Ms. Gaines and I had a very intensive conversation with him yesterday about this matter. So I am confused about his failure to appear today. So I would ask the court to consider an adjournment. This is a case of a very intensive amount of discovery, over 954 pieces of media on Axon to review. So I would ask the court.
You're requesting an adjournment?
Yes.
He said it was irrelevant.
My mistake, Your Honor.
I would be, for the record, I would be requesting an adjournment.
Really wouldn't matter. I'm gonna issue a bench warrant. People's requested bench warrant, bond 10,000 cash surety. Warrant will issue immediately.
Thank you,
Okay.
Your Honor.
I'll remember next time. Give him the cue. Court calls the case versus Daniel Keener.
Is that on behalf of the people, Your Honor?
Assistant Public Defender Davi Lebo for Mr. Keener. Mr. Keener, can you state your name, sir?
Daniel Keener.
Thank you.
And Your Honor, we just received some additional discovery on this matter towards the end of the day yesterday. I'd be asking for a brief adjournment to review that and also would like to address bond.
PC will be adjourned July 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. With regard to bond, I did have a chance to review the calls, and it is my understanding that the calls do relate solely to Mr. Keener getting his property back and having his brother pick up that property. He understands now the proper way to do that was to call the police, ask the police to arrive there first, and only obtain his property with the police present for a civil standby. He now understands this. He knows the seriousness of no contact order. He knows that violence of the court reinstate his previous bond.
Respond.
Your Honor, I leave this in the discretion of the court. I do want to know that I understand the calls, but I also would like to know that the defendant was not very honest with the court about what those contents of those calls were. And then one of those, or two of those calls, were one was completed to the victim, her number, after he was told not to have contact with her. While it was a short call, I do have concerns that he called her after he was told not to call, and then also about someone else to get in contact with the victim, identifying her by name. So I do have concerns, and I know he was remanded last week by the court. If he is to be released, I would ask him to be on home confinement, because given his bond violation in custody, I would have concerns about the bond violation out of custody. But I'm going to
Tell you no contact. Okay? And I don't know, and I'm unclear that his reasoning for why he says he's contacting, I don't buy it. I mean, I think it's clear. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Lance Ford.
people, Your Honor.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Ford. Would you please state your name for the record?
Lance Ford. Thank you.
Your Honor, we are continuing negotiations for this matter and would ask for an adjournment.
Without objection, July 9th, 2026, 9 a.m.
Thank you.
Thank you. Court calls case People versus Crystal Lewis.
Assistant Public Defender Zach Vinny with on behalf of Ms. Lewis, who approaches. Lewis, can you please state your name?
Crystal Lewis.
Your Honor, we're seeking an adjournment for the negotiation. Well, then I would ask to be heard on bond as well.
Matter will be adjourned July 2nd, 2026, 9 a.m. Esteban.
Esteban, Your Honor. So Ms. Lewis is currently on a $10,000 10% bond, which is not a bond that she can post. She does have a stable place to live. She lives locally in Ypsilanti. She does also provide home health care for her long partner's mom, Your Honor, as well. She on June 11th, her long-term partner had a serious heart surgery, and she has been unable to see him or check in with him or see how he's doing or, help him out. She has two daughters at home, an 11-year-old and a 19-year-old. Wait, is your 11-year-old a daughter or son?
Son.
Oh, sorry. I apologize, Your Honor. An 11-year-old son and a 19-year-old daughter. She will wear a tether if necessary. She will drug test if necessary. She'll do what she has to do. So she is asking for consideration of a personal recognizance bond so that she can, be out and help support her family. And then also, lastly, Your Honor, it is her birthday next week. She'll be turning 49 years old, and she would prefer to spend that with her loved ones.
I hear they have good cake at the jail. Response from the people?
Your Honor, I see that she has a benefit warrant out of the 44th Circuit Court of Powell. I also see that she would appear for a motion to carry.
A motion hearing?
That's what my notes said. Failure to appear for a motion. If
What's the bench warrant out of how?
I can have one moment.
Yes.
I also see consumption for you.
And does it give a bond?
Bond.
So it would be useless for me to release her because she'd be going to Howell.
If you were biggest here, you'd be going to Hall anyway. So you'd still.
Motion for bond reduction denied. Bond will continue.
Your Honor.
Yeah. Court does call the case of the people versus Stefan Wainwright.
The nine people, Your Honor.
Assistant Public Defender Davi Lebo for Mr. Wainwright.
Mr. Wainwright?
Yeah, they're going to get the keys to open this food slot.
Okay, thank you, sir.
Your Honor, we do still have some competency concerns. We're going to be seeking independent evaluation. We have begun reaching out to experts for that purpose. We're hoping to find one who can do it a little bit sooner than the date we were given.
Oh, do what?
An independent evaluation, Your Honor.
So, say that again, Mr. Lebo. You're trying to get the independent evaluation.
Yes, Your Honor.
You're trying to do it sooner?
So we have reached out to one expert who could potentially do it. He's given us a day of after Labor Day. We're hoping to find someone who can do it sooner than that.
So I'm trying to get released. So if you can do a personal recognizance, we can speed this process up so you can stop bullshitting yourself. So now that you understand that, if you don't release me on a personal recognizance, there's really nothing much to talk about at this point. So it's your decision.
Alrighty then.
Because he's not my attorney. I'll pay for that. I have plenty currency. That's not a problem. But if you guys would like to meet in person, be much better. So I actually have a meeting to go to. I'm a little busy. So let me know. They'll let me know up front. What's your name? Simpson? Okay, let me know. And then once you do that, we can meet in person. I have a couple clients that I have to take care of right now.
I'll meet in person with anybody. I don't mind. All right.
He was in person yesterday.
Dependent.
Yes, Your Honor.
I think so. This was set, his competency, I adjourned his competency hearing to the 18th.
Yes.
You need that adjourned out because you're trying to get the independent.
Exactly, Your Honor. Thank you.
All right. Give me a date in August. Set it now. I'll adjourn it out to August 6th, 2026, 9 a.m. Bond at this point will continue. There we go. Thank you. Thank you, sir. What? No, don't. I'm Samson. Yes. No. Court calls the case, People versus Kalani Franklin.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. That's the public defenders and advocate at Ruby on behalf of Ms. Kalani Franklin Courtroom. Kalani, state your name for the record.
Kalani Franklin. You're okay.
And the court.
I have a plea forward for the form indicates that. Okay, I guess the added count too is retail fraud third.
Third degree, yes, Your Honor.
All right, the 93-day.
How many excuses should a judge listen to before finally saying enough is enough? That question took center stage during a tense courtroom hearing filled with missed appearances, bond violations, and frustrated defendants. One defendant claimed she was only delayed because she went home, stopped for food, and then reported for a court-ordered drug test. But the judge wasn't convinced. As the explanations continued, his patience quickly ran out. When the defendant began arguing and reacting to the court's comments, the judge immediately shut it down, making it clear that he wasn't interested in excuses or games. Later, another defendant failed to appear entirely despite speaking with his attorney the day before. That decision proved costly. The judge listened briefly, then issued an immediate bench warrant and a cash bond requirement. Throughout the hearing, the message remained the same.